Friends, today I would like to discuss about one most important article of Constitution of India, that is Article 14, which prescribes about equality before the law. So what is the meaning of equality, or what is the meaning of equality in the perspective of Indian Constitution, whether it is absolute equality or there is some reasonable restrictions? That is the topic of discussion today. Article 14 of the Constitution of India provides that states shall not deny to any person equality before the law and the equal protection of the law. So two expressions are used manifestly in Article 14 of the Indian Constitution. Now, first expression, that is equality before the law, it is taken from the English common law. So the origin of the first expression, that is equality before the law, it is taken out from the English common law, and the second expression, that is equal protection of the law, that is taken out from the American Constitution. So English common law and American Constitution are the sources of these two vital expressions which are manifested in Article 14 of the Constitution of India. That's why it is prescribed that states shall not deny to any person equality before the law and equal protection of the law. And equality, what is taken out from the English common law and from the American Constitution, the main purpose is to protect or to pursue what is enshrined in our preamble of Indian Constitution, that is equality of status. We know that our preamble of Indian Constitution prescribes of equality of status. So this equality, what is used in Article 14, that is actually pursuing the object enshrined in the Constitution preamble. Now let us have a look what Article 14 says, that equality before the law, that states shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. So these two keywords are to be discussed in detail, that what is the meaning of actually equal protection of the law and equality before the law. So this equality and equal protection, these are the two essential words which are to be discussed right now. Now let's discuss about the meaning of the word equality as enshrined in Article 14 of the Constitution of India. Lord Jennings stated that equality means etymologically that among equal, law should be applied equally. Law must be administered equally among the equals. And not only that, like should be treated alike. So that is the concept prescribed by Lord Jennings. Whereas Dicey in England, we know in his principle rule of law, Dicey emphasized about equality before the law. So what Dicey states that before law everybody is equal. That means he prescribes about a single system of court. That means ordinary court of law should be there for all. There must not be any discrimination amongst the subject on the basis of any religion, creed or place of birth or whatever may be the social position or rank. That means whether he is ordinary citizen or private person, or whether he is any government official or anybody of the royal family, everybody should be treated alike. That means before the ordinary court of law, everybody should be tried, and which is actually opposing the concept of French concept of droit administrative. We know that under the French system of droit administrative, there were two parallel system of judiciary. One belonged to of the common law court and another is the for administrative court. And we know that in common law court there was the case which were dealt, that was between the disputes between the private persons only. But if there was any dispute between the ordinary or private person with any government servant or something, means public officer, that was to be dealt by administrative court. That means the higher in rank, that means who are holding the high position or any government official or something, they were not to be tried before the ordinary court of law. That is, there is a bifurcation of the judiciary as in the French concept of droit administrative, and which was actually opposing the view of equality of law as enshrined by Dicey. So our constitution also emphasized upon the equality, that means whether he is the position of any high status or whether he is an ordinary person, everybody should be tried before the common court of law. That means in India also the principle of rule of law, that means equality before the law, is applied in pursuance of constitution. That means here in India, whatever may be the social position or a creed or religion or place of birth, everybody are subject to under the same law and are to be treated before the court of justice, the same court. So this concept what I have discussed, that I have discussed about Lord Dr. Jennings at first, then Dicey, who has stated about the equality before the law in his rule of law theory, and droit administrative, that was in France. In Kedarnath Bajoria versus State of West Bengal, our apex court stated the meaning of equality. Apex court in this case stated that equality does not mean that law under all circumstances will be general in character or universal in its application, or it does not mean that state will not have any power to distinguish or classify among the persons or the things for the purpose of the legislation. That means state has the power to distinguish or classify the persons or things for the purpose of the legislation, and law cannot be considered as general in character or universal in its application. So in the Kedarnath Bajoria versus State of West Bengal, this was stated by the apex court. And also I am citing another important judgment, that is State of West Bengal versus Anwar Ali Sarkar. Supreme Court also stated in this view that what is the meaning of the test of classification. In Anwar Ali's case, our apex court, Supreme Court, stated that for the test for permissible classification, two conditions must be fulfilled. What are the two conditions? First is that the classification must be founded on an intelligible differential which distinguishes persons or things that are grouped together from others left out of the group. So one group and others who are left out. And second condition is the differential must have a rational relation, that means reasonable relation to the object sought to be achieved by the statute in question. So these two criteria must be fulfilled for tests for valid classification as stated by our apex court in Anwar Ali Sarkar's case. So what appears to us that if there is any classification made by the statute itself, it must be on the basis of some reasonableness. That means there must be the reasonable classification. It must not be any arbitrary or unreasonable classification. As for example, it can be cited like what section 11 of the Indian Contract Act states, that minor cannot enter into the contract. That for competency to enter into the contract, two criteria must be satisfied, that the person must be of sound mind and must be major. That means minor are not allowed to enter into the contract. So this classification of major and minor, that means only the major persons are entitled to enter into the contract, whereas minors are not able. So this classification is based upon the reasonable classification. Reasonableness is there. This is not arbitrary. Similarly, in case of Hindu Marriage Act, section 5 prescribes that for bridegroom marriage age is 21 years and for bride the age is 18 years. So this bifurcation, that is 21 years for the bridegroom and 18 years for the bride, this is a classification, but this is based upon some reasonableness. That means this classification is not based upon any unreasonable or unjustified classification. So that's why though these are distinguishing between the persons, but still these are valid because this is based upon the rational or reasonableness. Now I am discussing about one landmark judgment of D.S. Nakada versus Union of India as given by our Supreme Court, where the Rule 34 of the Central Pension Rule was declared as unconstitutional, because by that rule a classification was made that if any employee retires before a particular date, the rate of pension will be applicable for them was on the basis of old rate, and if the retirement is after a particular date, then the rate of pension will be applicable on the basis of the new rate. So Supreme Court stated in this case that the rule is unconstitutional because the basis of the classification is based upon the arbitrariness, and it is entirely unreasonable, and there is no help for the retired person because pension is made for them. So that's why in D.S. Nagara versus Union of India, Rule 34 of the Central Service Pension Rule 1972 was struck down as unconstitutional by the Supreme Court. Now I am discussing another landmark judgment, that is Mithu versus State of Punjab. In this case, Section 303 of Indian Penal Code 1860 was declared as unconstitutional by our Supreme Court, because Supreme Court stated that whereas in case of Section 302 of Indian Penal Code, where the punishment is imposed in case of the ordinary murders, there are two options, that means death penalty or life imprisonment. One option is open. But in case of Section 303, no other alternative is open. Their death penalty, imposition of the death penalty is mandatory in case of application of Section 303, which Supreme Court held that it is unconstitutional, and the classification or differences made between the application of Section 302 and Section 303, where in case of Section 302, where there is the option of imposition of the sentence, that means conversion of death penalty into life imprisonment, is available, but in case of 303 such option is not available. There is the mandatory direction of the death penalty is imposed, and Supreme Court stated that Section 303 is held as unconstitutional. As Mithu versus State of Punjab, Section 303 of IPC was declared as unconstitutional by our apex court. The main reason of declaring Section 303 of Indian Penal Code as unconstitutional was that because Section 302 and Section 303, that means in 302, if the murder is committed by any ordinary person first time, and in case of 303, if any person who is already sentenced for the life imprisonment, if the murder is committed by him. So what is the basis of the classification? That if any person first time commits the murder and then he is sentenced for life imprisonment, and then if he commits during the serving the imprisonment commits murder subsequently, then what is the reason of this classification? So Supreme Court thinks that this classification, that one, if the murder commits by any person at the first instance, or if any person commits the murder while means undergoing the life imprisonment, so this classification is not a reasonable classification and arbitrary in nature. That's why Supreme Court struck down Section 303 on the ground that this is unconstitutional. In K. Abbas versus Union of India, the Cinematograph Act was challenged because Cinematograph Act classified the films in two categories, A film and U film. U film means which is unrestricted exhibition is allowed. That means universally it can be seen. But in case of A movies, that means only it can be exhibited before the adults only. So the petitioner's contention was that this classification, that means U and A in the Cinematograph Act, that is unconstitutional, and because the classification is unreasonable and arbitrary classification, because their contention was that exhibition of the movie or film, it is like a kind of expression. There is expressions like book or painting or sculpture. So movie or film is a kind of exhibition or expression. So in case of book or painting or sculpture, no prior restraint is imposed. There is no kind of such A for adult or U for unrestricted exhibition. No such categorization is made. Then why it is best in case of the exhibition of the movies? But Supreme Court stated that this classification is absolutely reasonable classification because movie or motion picture, it is a different kind of exhibition which is segregated from other sorts of art or cultural representation or other type of freedom of expression like book, painting or sculpture, because the motion picture has a tendency to stir up our emotions more deeply, particularly when it is exhibited before the children, because children by their nature they can imitate the motion picture. They actually imitate the performance of the heroes or somewhere what is shown in the motion picture. So that's why Supreme Court stated that though it is a kind of expression or art, but motion picture which can stir up the emotions particularly of the children. So that's why Supreme Court stated that the classification A and U as prescribed by the Cinematograph Act is valid and constitutional. So in K. Abbas versus Union of India, Supreme Court stated that U film and A film classification under the Cinematograph Act was held to be valid. So whatever judgments I have already discussed, that T.S. Nakada and also the Mithus case and K. Abbas, so there is a picture comes out that in what circumstances the classification is permissible and under what circumstances classification is not permissible. What is that means? Equality before the law as prescribed in Article 14, which does not say about the absolute equality. Classification can be made, but it must be on the basis of some reasonable classification in view of these judgments what I have discussed.